simp. A simp, not a simp. We eat so many shrimp. I got iodine partners.
My bitch a choosing lover, never fuck without a rubber. Never in the sheets like it on top of the cover. Baby, you been no time to get down with the team. Disgraced is seven wonders of the world. And I can make you the eight if you wanna be my girl. Girl, say my girl, I don't mean my woman. That ain't my style. Need a real street stalker. Stalker, walk a green mile. Piling up the paper on the dining room table. Cause you able to realize I'm the truth and not a fable. Baby, rockin' Russian sable. Keep that chiller on the rack. What I look like with some $1,000 shit up on my back. I'm $1 million man that need $1 billion bitch. Put my pimpin' in your life. Watch your daddy get rich. Easy as ABC. Simple as 1, 2, 3. Get down with UGK. Pimp CBU with B. Cause what's a hoe with no pimp? And what's a pimp with no hoe? Don't be a lame. You know the game and how it goes. We try to get chose.
A simp, not a simp. A simp, not a simp. A simp, not a simp. We eat so many shrimp. I got iodine partner.
Hello. Hi, everybody. It's Artie of Artie's Cover Fiction. Happy Wednesday to all of you. First things first, the Right to Travel video Telegram event has been postponed. So I moved it to next Wednesday. In the meantime, because I know I disappointed all of you for cutting the stream short yesterday, I went to look for the parts of the Judge Christine Peterson's defense of PJ's contempt hearing, and I was able to find it. It looked like it was the video that was hidden, but I found another copy. And so we're gonna take a look at that. And I haven't seen it all the way. I've only seen the very beginning, but it starts to get pretty interesting. She's definitely on the hot seat because she's being questioned not only by the what we would call the prosecution, but also by the judges as well. So put this here, and I'm gonna make sure that this is all good. Hey Pedro, how you doing, man? Meanwhile, it's hot. It's a hot day today, so. I'm having a hot date. Ha! No, of course not. I'm forever alone. Why would I have a hot date? They're stipulating to the exhibits as in the translated copy of the birth certificate, and I think the original as well. What are those? Hey, everybody. Hey, Draco. Thank you for the gifted membership. Oh, so before we go in, there's a couple of there's a couple of things I want to tell you guys that's going to be relevant to what the discussion is going to be. There's going to be discussion on indirect and direct contempt of court. It is also referred to. It could also be referred to as civil contempt or criminal contempt. What those mean is that direct contempt is what it sounds like. You are acting in a way in front of the judge that is not proper, not proper decorum. You're acting in a way that is warranting the judge to hold you in contempt of court, but it's happening directly in front of the judge in the judge's presence. Indirect contempt usually involves a violation of a court order, something that happens outside of the presence of the judge. I think in almost all instances, jail time is never imposed on indirect contempt. In direct contempt, jail time can be imposed, but not always. The reason why is because with a civil contempt, it's considered to be an infraction, but that's not, because it didn't happen in front of the judge. You can't put them in jail because that's going to be a violation of their constitutional rights, because the judge is summarily jailing you for something that you did that's outside of the judge's presence. Excuse me. There's another thing that they're gonna talk about that I wanted to explain, but I forgot. But that's one of the main parts that I wanted to give to you guys before going in here, because it's going to be very relevant soon on the distinctions between direct and indirect contempt.
We agree to their copy.
Great, thank you.
All right, Judge Peterson, in reference to complaint number 2021-339 and the contempt issue, on August 24th of 2021, you jailed the petitioner in that matter for the fraudulent misrepresentation she made to the court via her filings with the court on May 3rd of 2016, correct?
Your Honor, I do object to the term used, jailed. She found her in contempt, and the jail was the resulting sentence. Asking her if she jailed her implies that she took some extrajudicial action, I believe.
Okay, well, she's on.
Sounds kind of mean.
She can frame the question, and I'm confident your client's about to clear that up, but if not, I bet you will.
That was one of the reasons. The main reason is because she submitted a fictitious document to the court. But she was held in contempt for that.
Okay, so your testimony here today on September 9th of 2023 is that the main reason you jailed her was because she submitted a fictitious document to the court?
I didn't say the main reason. I said that was one of the reasons.
Okay.
So the fictitious document that she submitted to in the court while we were in court was an issue, as well as her testimony in court on that day.
Judge, would that have been a crime?
Yes, the fictitious document, it would have been forgery.
Did you report it to anybody in law enforcement, sheriff, GBI?
No, because it was done in court while I was on the bench. I held her in contempt.
Crime, isn't that a felony?
Well, it would be, but I wanted to see if her real I want to see what the real document is. I gave her an opportunity to show what that is. But yes, it's a crime. The document that was submitted, it's not a legal document. She was submitting it to the court as if it was her original birth certificate.
What was fictitious about it?
It stated not a legal document, not to be used for any legal purposes. And so obviously it wasn't a real item.
So what if I was in that position, if I was in the judge's position, I would say, I'm sorry, but I can't rely on this document because it's not certified. I wouldn't throw her in jail. I wouldn't summarily throw her in jail. Like normally, I feel like a judge would say, "Sorry, we can't accept that. You'll need to get you'll need to get a certified copy." And I don't know if I would call that fictitious, because there would be nothing fictitious on it. If she's attesting that this is my dad's name, this is my mom's name, this is my name, this is where it's from. It's just that you just can't use it for in an official proceeding or as a legal document. But what's on the paper is not fictitious.
Well, when you say fictitious, that sounds like she fabricated or forged or altered a document.
Well, Judge, I wouldn't know what, I'm sorry. What do I call you, Mr. Lopez?
That's what
I wouldn't know what it was. I just know that the document, what it stated, and I know what she testified to in court.
Well, hold on. If you don't know what it is, then
You just told us that she submitted a fictitious document, and now you're.
You said it was a ridiculous document, but now you say you don't know what it was.
Without interrupting us, you're saying, "Oh, I actually have no idea what it was, but it was so fictitious, I locked her up."
Well, it was
Right, so-
fictitious. If you look at the bottom of this document, right there, it's very faint, not recommended as a legal document. This accompanied with.
The language is even passive. Not recommended as a legal document. The language itself is like very passive.
And I got testimony from her in court about all the proceedings and all that she's done. And she admitted that she's been lying. She's not giving the court the correct information. She's only doing this to get her mother back in the country from Thailand. So this all came out on her.
Oh, okay. So now she's making the hard, strong claim that she's trying to fix the birth certificate to get her mother into the States. But again, the problem is that the marriage certificate has her mother's actual name on there, and a birth certificate has her mother's actual name on there. So in either way, there's nothing that's untoward here. That the issue was the father's name.
Sworn testimony.
So what you told us was one of the reasons you held this person in contempt was that she submitted a fictitious document. And what you're now saying, I don't know what's on the screen, I'm sure it'll be explained in a minute, that it's not to be used for, I don't know what language you're pointing to. That's real faint. I guess it says not recommended as a legal document, but what makes that fictitious? In fact, it says on there.
Certified translation.
Certified translation.
First part says certified translation.
That's
But not recommended as a legal document. So what's the fictitious part of the document that caused you to decide this woman needed to be held in contempt?
Well, when I'm on the stand, all I can look is what's in the presence of me at the time I'm on the stand. When I reviewed the information, it was not a legal document. When people come to change, I'm over vital records. So when people submit records to me for changing, or when they have to bring certified true copies that are legal documents.
Judge Peterson, I think I'm having a hard time with the semantics of this. Fictitious to me means this is not true. This is
Right.
Somehow she has taken a document and changed information that is not true,
Okay, I get it.
and it is false. And it is a fraudulent document. This is my understanding of what you're testifying to is perhaps you didn't think this was a fully certified document that you could base a decision on as to whether this is
Exactly.
accurate or not.
Exactly. And in most cases, you as a judge would be like, I'm sorry, I can't accept this. We need a certified true copy. And so we'll set this matter for, later down the line. You don't throw her in jail.
That's different than saying she went and created a false, fabricated a false birth certificate
Mhm.
and then tried to pass it off as a real birth certificate or a copy or a translation of one. And that's where I'm having a hard time, because this says it's a certified translation. And I've dealt with this because I had to get my birth certificate from Puerto Rico and it's in Spanish and I had to get it certified and
Hey.
all that good stuff. So I can use it here in the US. But to tell me, look, I need something more official is one thing. To say this is a fictitious document is where I'm having a hard time.
Well, maybe it's the wording. So when I say it was not legal, it's not as a legal document. When it says, so remove fictitious, it's not certified or
Okay, so now she's walking back from saying it's
not
fictitious.
recommended as a legal document. We generally don't even take copies. We would take the original. We need the original to verify that the information you're giving me is true.
Right. I agree with all. Could you have just told her that and not say, I'm here finding you in contempt for defrauding the court because you just turned in a document that's not certified? And it is
Yeah.
certified translation, but I understand the point you're trying to make.
But what I'm saying is it wasn't just that. It was everything. It was all the testimony that came out at the court, and she admitted to defrauding the court and lying under oath. And now she's presenting this document. It was the totality of what was happening in the court.
Is there a
And
transcript?
let's walk through that, because I think Ms. Veal wants to do that.
Yeah, I'm sorry.
No, I shared the same concern because the first words out of Judge Peterson's mouth were fictitious document.
Yeah.
And I'm not seeing a fictitious document, but it could be when coupled with the testimony of this person, the judge was under the apprehension that this document was something that it wasn't.
My parents, fun fact, my parents still have my original birth certificate. I have a certified copy in my special container in my closet.
And then we get to where we got. So
Okay.
And
take it
just-
away, Ms. Veal.
Sure. There is no transcript of this proceeding. correct?
No.
Because litigants who come into your court have to bring their own court reporters, pay for them if
Yes.
they want it taken down, correct?
Yes.
So there's no record of the proceeding.
Oh, there's no record of the proceeding. That sucks. So we can't really. Well, so we have to rely on JP's testimony and her testimony as to what was said and what was said.
No.
Okay, so what we have then is your word and the petitioner's word. regarding
And-
what happened.
And the clerks that were present.
Okay, we'll be glad to hear from them. Which clerks were present?
My chief clerk would have been there, Bonnie Fasik and Sandra Hall.
Judge,
Hey,
would you
Offish.
consider that proceeding a contested matter,
No, contested? No.
because contested matters would have to have a verbatim takedown, right?
Well, in my court, we don't ever supply, the only thing we're required to record under probate laws is guardianship proceedings. So
Hey,
it's not-
Big N too. What's up, man?
It's the petitioners or the parties' duty to take down.
Everybody shout out Big N the second. Check out his channel. Always has good stuff on there. Shout out to you, man. Thank you.
So if there's going to be a big fight over a will, it can be taken down, but the parties would need to supply.
Right.
a court reporter, and you put them on notice. Hey, if you want a record made, you should show up with us tonight.
That's right.
All right, so I'm showing you Judge Peterson, exhibit, JPC exhibit 33.
Mhm.
And this is the petition that was filed. Where, and I'm going to refer to her as PJ because those are her initials and I don't want to mess up her name. Or the petitioner, but PJ came into your court voluntarily on August of 2021, filed this petition with your court and says father's name should be, and then she's got presumably her biological father's name, correct?
I'm reading what I didn't take this petition in, but yes, that was filed with my court.
Okay. But you saw this petition at or around the time it came in, right?
No, I saw it at around the time that I would schedule a hearing. So whenever that was, I don't get it right when it comes in necessarily.
What's the typical gap?
Oh no, I think she messed up. Hold on, let me check the order. I know I have the order. Oh no. Oh, I thought I had a copy I thought I downloaded a copy of the order that she held against her. So the issue is that I think they're going to confirm it, but I think she in her order holding PJ in contempt, she stated that she was alerted to her fraud on the same day that she filed her petition.
If I bring a petition in, is my hearing in a week or a month or?
It depends. It depends. I have a full array of cases that I handle. So it's however they get to my desk, however they get to my office. I don't know. It just varies. Some petitions require service, so they might be delayed. This one probably would have been placed in a bin. I don't know if we had bins around that time. We've got more organized, but I'm not sure how long it would have taken to schedule.
Okay, so your testimony is you didn't see this petition until you said at or around the time of the hearing, correct?
At or around the time, when I received the petition, I would have scheduled a hearing because they're asking for an amendment to a record.
All right, well, I'm gonna show you exhibit number 35. This is actually contempt order.
Yes! Oh no! Oh, she's screwed! Oh no!
Third sentence. This court was alerted to the fraudulent misrepresentations on August 2nd of 2021.
Yep.
When PJ filed a petition to amend marriage record.
Yep.
Okay. When I was alerted, but that doesn't mean I saw the file. So anytime somebody comes in my office and there
Oh
is
my
some
God.
issues at the counter, I always get alerted to the issues. So that was one.
Does that mean alert? Is there a little button you hit?
No, you don't hit buttons in there. Stay away from the buttons. No.
Yeah, you better.
Anytime there's issues, like there's been.
She either misremembered or she lied. Because she originally testified that she was not aware of her petition until around the time that she filed it, and she explicitly said that she would not see the petition on the same day it's filed. But now we're seeing that in her order, where she describes how she held PJ in contempt, she explicitly says in there that she was alerted to PJ's incongruencies on the same day that she filed.
I mean, for example, people might come in and they might have active warrants. I might be alerted or things
What
like,
you mean is somebody that works for you says, hey.
yeah,
this dude's got an active-"
right.
Gotcha.
So that was what they would let me know.
You were alerted to the fraudulent misrepresentations on August 2nd of 2021, correct? So on August 2nd of 2021, you were of the conclusion that there were fraudulent misrepresentations involved, right?
Was alerted. I'm saying that's what the court was saying.
So this is going to create an issue, because what she's saying in her order is that she, before even the hearing, before even the having a hearing at all, she already prejudged PJ as providing a fraudulent misrepresentation to the court.
Stating, yes, at that time.
You're the court, so.
Yes,
were you-
I'm sorry, my clerks. Yes. So that's what my clerks were representing to me. And then after we had the hearing, it was confirmed.
What was the fraudulent misrepresentation? This is your contempt order, by the way.
This is a
What was the
portion.
fraudulent misrepresentation
I don't know if it's a portion. I think it's the whole thing.
that you were alerted to on August 2nd of 2021?
There was a lot of misrepresentations made. So
I don't know would work. I think she came into office in 2019 or 2020? I think it was 2020.
Miss PJ came to the counter. What was told to me was that she wanted to amend their marriage record. What was told to me was she was only changing the marriage record because she was trying to get her mother into the country from Thailand. She represented that she always knew who her father was. She just put on the paper that it was her uncle. I mean, not her uncle. She also put on the paper someone else because she wasn't in talks with her father. So that's what was told to me. So naturally, either way, when she's asking for a change, we have to have a hearing so she can present legal document, true documents to authorize the change. Obviously, it needed to be changed because she put information up to the court that she gave the wrong information. So it had to be changed.
Would it be better had all that been in your order, all the misrepresentations you say she made?
Yeah, it would. It would be a lot better if you actually put pen to paper as to what she did, because there's no record. There's no transcript. There's nothing you can go back to. All her order. All right, let me find the freaking order. Hang on a second. I'm going to find the order itself so you guys can see it. Because I know I could have sworn I downloaded it myself. But I want to show you guys this. Judge Christina, Peterson, misconduct. Hang on. There we go. That's 2021. Okay, where is? I know I saw the damn. Affidavit of, no, that's not her. Aha, I think it's in here. Yes, okay, I found it. All right, I got it. All right, let's Okay, this is the petition that PJ submitted. Petition to amend marriage record. Father name should be this. Birth certificate, translation. And then you'll see filed August 2nd, 2021. Exhibit C is the notice that she sent. August 12th. Exhibit D is the contempt order. This is it. It's a single page. 3 paragraphs is the contempt order. 20 days. I know I said 30 days. I said it's actually 20 days. She actually, the PJ spent 2 days in jail and then had to pay her husband had to pay $500 to get her out. She applied for a marriage license, although she took it over before the clerk is certified that all is true for correct. She willfully provided false information. This court was alerted to the fraudulent. This court was alerted. This court means her. This court means her, but fine. Was alerted to the fraudulent misrepresentations on August 2nd, 2021, when she filed a petition to amend our marriage record. This court frowns at anyone who dishonors the judiciary by lying under oath and providing false information. This court finds her in blatant disregard of the laws of the state of Georgia, evidenced by her fraudulent misrepresentations to the court via her filings, not her testimony. Not her testimony, her filings with the court. And that's it. She sentenced her to 20 days, and then she can get out if she pays. She can get out by August 26th. If she pays $500. So, yeah.
Instead of just misrepresentations.
Um,
The reader doesn't know, right?
perhaps, yeah. This was
Perhaps.
2021, so I was just getting in there. So I'm more
I
detailed.
understand that you applied for the job.
Yeah, I did. And I get better as I go. So yeah.
Just okay. Let me unpack this a little bit. So you're saying that
Uh-oh.
at some point she admitted that she was the reason she's trying to amend her marriage certificate is because she's trying to bring her mother into the country, correct?
Well, she said that in court, but that was the representations in that some of the clerks say she made, but she did that as well in court.
Okay. She's only trying to amend her father's name. She's not making any change to her mother's name on this record. So that's my
Correct.
confusion.
Yeah, it was my confusion.
Exactly.
too. It's still confusing.
Yeah, so why? So then why?
I don't know. Maybe I don't know how that works in getting people in the court, but that's what she testified to.
She
So-
also,
Go ahead. I'm sorry. Go ahead, Ms. Veal.
she also told you that the reason that she put her biological uncle's name on there was because he had raised her from the time she was a baby, correct?
No, she didn't. She said the reason why she wasn't speaking to her father. She never stated why she put anybody on there. She just said she wasn't speaking to him and she didn't want to put him on there. And honestly, you have to put anybody. I mean, we've seen some licenses that don't have, or applications that don't have a name. It would have been better to put that rather than to just blatantly lie and swear under oath.
All right, well, let's talk about blatantly lying. On August 2nd of 21, you've already concluded that she
Oh, here we go.
fraudulent misrepresentations to the court, correct?
No.
Wait, what?
Okay, you on August 12th of 2021, and this is exhibit number 34. You then send, or your office sends, a notice of trial or hearing on a petition to amend marriage record, which provides that a hearing has been set in the matter for 10 a.m. on 8/24/21. So 12 days after she filed the petition, quick hearing. And you provide that you must appear in person. Video conference is not available for the hearing. And you also say court reporting is not arranged and is your responsibility.
Right.
And
There are
this is the
certain
entirety of the notice that was sent to her, correct?
Right. And there are certain hearings that are not, video conferences not offered, especially if the court needs information or documentation. As in this one, it wouldn't have been video conference offered.
You ordered her to come to court, having already made up your mind that she had willfully provided false information on her marriage application, correct?
No, this order was done after. I'm sorry, what are you asking? Yes, this order was August 24th. You asked me about when I asked her to come to court. So just because my clerk states something at the counter and alert me to something doesn't mean the judge or the court has made a ruling on what happened. Regardless of what she would attest, what she testified to, that's not here nor there. The point is, she wants to amend her marriage record. She needs to bring sufficient documentation to do so. But the information that she presented to the court on that day, as well as the material she presented, it wasn't true. It was not sufficient for the court to make a good ruling on. And I had an issue with that as the judge on it.
But having insufficient documentation to grant the amendment is not grounds for contempt. It's not grounds to send her in jail for 20 days.
I'm sorry, those sounds like two different things. Not sufficient and not true. Which
Exactly.
true, or is it not
It's
sufficient?
not true. It wasn't sufficient. I wouldn't have been able to issue
And now she walks that back.
amend any type of vital record with what she submitted to me. And combined with the testimony that she's given us, she lied under oath, that she's only doing this to get her mother in the country, combined with all of this information, that was an issue for the court at that time.
But if all of that's true, if you think, would it have been better in your view to have somebody, a separate entity, person, look into that and make investigative findings and then come back to you, or maybe report it to the district attorney or something, instead of you handling it yourself?
I mean, in probate, we don't have that. We don't have those resources to do that. So,
You have a district attorney in Douglas County.
yes,
We have the title of Attorney General of Georgia, right? Yeah.
yes, yes.
So you could have picked up the phone and reported that to anybody, any police agency, right?
Yes, there's a lot of things I could have done, but, and it could have been done any different ways.
The whole reason why we're here, Judge, is due to your judgment.
If I could have done it, I wouldn't have done it this way. But this is the way that in that moment, that's what I felt was the thing to do. Now, when I have cases that come in like this, I make referrals to the district attorney's office to do investigations. I've sent things, and I copied the sheriff's office as well, to investigate. So I've done that, not that they respond, so I don't know if they're picking it up, but that's what I have done now.
You didn't want to, or did you want to send her to jail when she came in for the hearing?
No, I did not.
Okay. But you knew that when you ordered her to come in for this hearing, you were going to ask about, to use your words, the fraudulent misrepresentations. Correct?
I'm sorry. I knew I was going to ask about them.
You knew you were going to ask this woman about what you had determined were false, fraudulent misrepresentations. You knew you were going to ask her about that during the hearing.
I didn't know they were fraudulent misrepresentations until she confirmed them at the hearing.
Okay. So you were going to ask her about that because you were alerted to it on August 2nd of 21.
I was going to ask her about the amendment and why it was necessary to make the amendments. I have to know why. Why are we amending your father's name? Did your father change? Did you get adopted? That's a court inquiry. That's a proper inquiry that I would make when someone's trying to change this type of record.
And your notice contained no mention of contempt allegations or no mention of fraudulent misrepresentations, correct?
It wouldn't be, she wasn't held in contempt until she was at court.
Is this the first person you held in contempt? since-
It's not, no. Mm-mm.
How many people have you jailed?
Well, 2 people were held in contempt that were incarcerated, and 1 was held in contempt that was not. And the first one is when I kind of inquired about the contempt proceedings because we were never trained in it. But that's when I contacted the listserv and other probate judges. But the first one that I held in contempt, the DA did pick up and held him and filed charges against him.
Did you give any of these individuals an opportunity to consult with counsel before holding them in contempt?
Yes, now it's being, when they get noticed, they'll actually.
Oh, it is. Oh, so now Now you did. Now you're giving him forewarning.
If they know about contempt in advance. So if they violate a court order, they'll be served by a process server. And they'll get notice that you can get an attorney, and this is a contempt, it says contempt hearing when it's a contempt hearing. But the first ones were not contempt hearings.
You just held them in contempt.
Yes, because of what they did present in that court on that day.
PJ was not given an opportunity to consult with an attorney.
Right, because I didn't know it was a contempt. I didn't know she was be held in contempt until we were in court.
So the 3 folks you've held in contempt since you've been a judge.
Yes,
Counting this person.
counting this one.
Your testimony today is that you held her in contempt based on what happened in court, correct?
Yes.
But your finding in your order of
But it-
contempt.
Yeah, and that's what I saw too. The findings does not say that. The findings say that she held her contempt based on her filings, not based on what she stated or testified to in court. Yep, and she's calling her out on that.
Finds that PJ is in blatant disregard of the laws of the state of Georgia and of this court, evidenced by her fraudulent misrepresentations to the court via her filings with the court. And the original filing for a marriage application was in May of 2016.
No, I was talking about her filings in the court that she presented.
Oh, come on. Oh, come on.
Then
Weasel.
What we were talking about now that you just placed on the screen.
so
The
her petition to amend the marriage record.
So you've presented what you've identified as her birth certificate that is not, but you have her real birth certificate in your evidence. So that would be the true filing. But she did not submit that to the court. She submitted what you posted.
Okay,
Don't interrupt the witness.
this is your order from the day that you jailed her.
Yes,
You say that she is in contempt because she's in disregard of the laws of the state, evidenced by
Brr, I need a weasel emote.
representations to the court via her filings with the court.
right.
What is the filing that you were referencing in this order?
You've already put them on the screen.
So that translated birth certificate, if we could use the exhibit, so 61, can you put 61 on the screen?
Could my client look at the documents that we've stipulated in, and
That would be great.
I know the technology is good for display, but if she could see them, she might be able to, she has all of them in front of her there.
Sure.
Can you use 61, 62, and 63?
No, PJ is the woman that she put in jail.
Okay, 61 is what was filed. 62 and 63 came after the contempt. Those are the true copies. Those are the true documents.
Okay, so you were testifying today that what you meant in your order of contempt, the fraudulent misrepresentations to the court via her filings with the court, you have identified exhibit 61 to be the filing that you're referencing.
Yes, on top of all the other filings she did, but that was the filing that was submitted in court that day.
This was
To my
filed
clerk.
to you.
It was submitted to my chief clerk and to the court, yes.
And what is the fraudulent misrepresentation contained in this filing?
It is not a true document. It is not a birth certificate. It is not a vital record. It says not recommended as a legal document. So the court, you don't submit a non-legal document or something that's not recommended as a legal document to the court.
So if I'm a lay person, Judge Peterson, as I assume PJ was, not a practicing family law attorney or anything like that. And I hand you what I think, because I'm working with translation from a document from Thailand, and I hand it to you, and it has on there language that says, hey, this is a certified copy of the translation, not recommended as a legal document, but this is what I hand you.
Yep.
What's the fraudulent part about that? unless I say, please don't look over in the corner, ignore that language, or I mean, did she do something like that? Or she handed you the best thing she had? I guess the fraud part's not jumping out at me, and I think that's what Mr. Lopez.
Exactly.
At the outset of the conversation, but we've moved far enough along.
Mhm.
There didn't seem to be anything underhanded about the document because of that language in the lower left-hand corner. Why was the response simply, ma'am, this document doesn't suffice? I mean, you're the judge. If you say
Right.
it doesn't.
Exactly. This is what it is. Why would you just, because, and this is why there's nothing, yes, that's Judge McBurney. What else, what are we supposed to think if not you had a bone to pick with this individual? Because any other judge would just simply say, this is not sufficient, come back when you have a true copy.
Suffice, then she's stuck and she needs to get something else.
Right.
It's not like she can say, aha, I say it is enough, judge, and you must accept it. And then,
Right.
all right, I'm gonna accept it. And then only later you learn that it's insufficient, which was the word
Correct.
used. And
Yes.
I've got to tell you, you have shifted your words a whole lot on this one. But
Yeah, she
your
did.
order says fraudulent misrepresentation, and you have now said Director 61 was that document. That was the filing.
Yes.
That was the fraudulent misrepresentation. I'm trying to figure out what on here is fraudulent. On its face, it alerts you, hey, maybe you don't want to rely on this. Your
Mhm.
call, your discretion, whether
Right.
to rely on it or not. You can not rely on it. Sorry, PJ, you're out of luck. I can't go forward with this amendment. Or this is complicated. You're from Thailand and you've done the best you can. I'll exercise my discretion, enter an order allowing you to amend your marriage certificate. Option 1, no, thank you. Option 2, yes, we'll do it. Where does option 3, I'm locking you up, come from?
Well,
Exactly.
see, so we can.
So I'm going to say it here again, the evidence for this is very limited, but it's suggested, and the evidence comes from her social media postings. But the evidence suggests that she had a problem about PJ's husband.
Talk about what could have happened. If we talk
You know
about,
what? I don't, because we know what happened.
Yeah.
You locked her up, and you've told us it's because you wrote it. She fraudulently misrepresented through a filing.
yeah,
And you've now said this was the filing, and I'm looking at it. What on this filing prompted you to conclude that she was defrauding the court and blatantly disregarding?
well, it's the representations that she made on this filing. Well, not only this filing, when I said totality, it's all of the filings. So then we have other filings where she had to swear under oath and certify to the clerk that what she submitted to the court is true, honest, legal representations. She's admitted under oath that this is not, plus you're submitting this document that's not a legal document. So in totality, when I looked at it at that time, I felt like we had a contempt issue.
She admitted under oath that this was not a true document.
Yes, she
told you
said,
that this is not true. The
yes,
information on
well,
there is not
no,
true.
she said this was, I'm sorry.
That's why we let him finish his question.
She admitted under oath that this was not her birth certificate. And she said, I said, so this is not, where is your birth certificate and why would you submit this to the court?
Because it's in Thai! You wouldn't be able to understand it! I imagine she would have said that this is a translated copy of my birth certificate. It's not my actual birth certificate. Because the original birth certificate is in another language that you wouldn't know.
There was no, she's stating, I want to get my mother in the country and I need this name. So I'm confused on, is this a real representation of who you trying to, is this the person you're saying is your father? Is this your father? Is this a real document? Because she's testifying to things that are not.
Would it be appropriate? I mean, yeah. I mean, that would be better. That would have been probably better if she could bring her original along with the translation. But again, the throwing her in jail for this, what else am I going to think beyond this was like this is a personal thing?
Necessarily true, or she's admitted to lying.
I think you're sort of going all over the place here. I'm going to look at your order. The first part of your order says that she willfully provided false information on the marriage application.
Yes.
This order does not reference birth certificates, fictitious documents, or anything else. It just, the only reference to anything that might be fraudulent or misrepresentation is this willfully provided false information on the marriage application. And then the court was alerted to the fraudulent misrepresentation on August 2nd of 2021, when PJ filed a petition to amend. And this court frowns on anyone who dishonors the judiciary by lying under oath and providing false information to the court. Is that what the basis of the contempt was, or was it this document? You told us it's both, and it's fictitious and it's everything. I'm having a hard time understanding what the basis of the contempt.
This is half of the order. There's another portion of the contempt order.
Where is it?
Other order?
Where? What? How is this half? How is this half? The signature is right here. So ordered. This 24th day of, it's one page. One page, you Weasley liar. One page. The signature's right here. What are you talking about?
There's another portion. There's an order and notice.
Notice? What?
So there's a second page to exhibit number 35
What's
that Judge Peterson calls an order and notice.
Petition to compromise doubtful claim of minor.
That is, I know, that's my clerks. They drafted this, and this is what we were having to deal with.
Wait, what did it say? Hang on.
So they must then change.
As doubtful claim. Petition to compromise doubtful claim of minor.
That is,
So that was boilerplate, and so incompetence of her clerks, because I guess it included boilerplate of another type of petition.
my clerks, they drafted this, and this is what we were having to deal with. So they must then change that part. You were supposed to remove that.
So you didn't write this, you just signed it?
I didn't write it, no.
You just signed it.
So the information, the case number and the marriage situation, that's the correct information.
Is your clerk a lawyer?
Nobody's a lawyer in my office but me. And that's what, around this time, I was requesting.
Yeah. So it all falls on you. It's your responsibility to read what you're signing.
The Board of Commissioners to get me a budget for legal, additional support. And that was being obstructed by Judge M.
Maybe you should have took some of your salary, which apparently you had a hissy fit to make it to make yourself the highest paid judge in the state of Georgia. Maybe you should have taken some of that money and you could have used that to hire yourself a law clerk or somebody competent.
So I'm just saying it was hard. I was doing all of this by myself. I'm the only legal.
Could you have hired a lawyer, let me finish, part-time with some of your vital record money? Hey, tomorrow, if you wanted to.
Could I hire I guess I could. But you would, yeah, I've never considered that. I've never thought about that. So we can say what we could have, would have.
I'm the dumbest guy in the room.
But I mean, I was asking for a budget to get legal support, legal help. And I still haven't found a lawyer who would want to work part-time. So.
Well, Judge, I
Thank you.
don't think this order
Page for the $2.
answers any of my questions because it doesn't reference what the fraudulent misrepresentation was, what the basis of the contempt is. It also says that this case will be dismissed for lack of prosecution, which makes little sense to me.
Yeah.
Since you're the person prosecuting this person. pending, a certified birth certificate, official.
Think would work.
Which I understand why you'd want that in order to make your decision. I just don't understand how we went from, hey, this is not sufficient, to, hey, you're lying to the court, defrauding me, and I'm going to put you in jail for the maximum amount of time, which is 20 days with a fine of $500.
That's
So, so in the where is it? Their recommendations, their finding her guilty. They made a comparison that normally when you put normally for giving somebody the maximum, it's like, where is it? Where was it? Oh, dang it. Where did I see it? Where it's like the normally it has to be that the person's conduct is so egregious that they cannot function, that they're unable to function in the in a normal course. Like, we're talking somebody who is screaming, interrupting, shouting obscenities, losing their cool. Like, we're talking about something wild like that to get you the maximum. Her name is Christina Peterson. She's no longer a judge. She was bumped off last month.
That's not what, she was not in the maximum. That's not what the order stated. That's not what happened either.
You said she could purge herself if she paid, right?
Yes, and she was there. She purged herself immediately.
But if she couldn't, then she
She
was
was-
serving the maximum amount of time,
Yes.
which is
Yeah.
exactly what Mr. Lopez just
Is
said.
that
Yeah.
20 days?
Yeah, you gave her the max.
So at the time, the information presented to me, and when I speak about this order combined with the second, yes, it was the documentation. But when you have somebody coming into court swearing under oath that I knew I lied, I lied. And the only reason I'm changing this and updating the court is because I'm trying to get my mother into the country. Here is a copied version of something, a non-legal document. So I want you to take this as true on who my father is, even though I swore on the oath that my father was over here. That was an issue to the court. That was the decision that was made on the time. It appeared like it was a fictitious document, or what I thought as a fraudulent document, as well as the representations and the lies under oath. So I did hold her in contempt. Yes. If
I
we
don't think of it
were
at
to
10
do
months.
Now I would probably refer it out.
I don't know who the judge in Ohio is. You'll have to refresh my memory.
To the DA's office, or give her an opportunity to submit me a real legal document.
Judge Peterson, the reason and this is an area that I'm particularly sensitive to, I'll go ahead and tell you now.
Mhm.
It just seems to me, and putting aside whether you did the contempt right or wrong, it just seems to me like such a harsh sanction for someone who's coming into a probate court, who wasn't given an opportunity to get counsel, who had no idea that this would become a contempt hearing, had no notice that maybe I should get this taken down because this is not just a simple petition to amend marriage record anymore. It's become something more. It just seems like such a harsh sanction to go from, 0 to 60 and go from, you could have just denied the petition and said it's not sufficient, but you went all the way to the maximum penalty that our law allows for a contempt on someone who's in a probate court. This isn't a criminal matter. It's not. I mean, I guess I'm struggling with this because in 11 years on the bench in state court, where people routinely would say things that I thought were misrepresentations, and I held people in contempt. I put someone in contempt for a day
Mhm.
for something that I thought was pretty egregious. But this, I don't know, I'm struggling with, do you not feel like this might be a harsh sentence for someone who's just going to your probate court to get something amended?
Well, I feel like it's harsh. And when like I said, if I had an opportunity to do it again, I would have given her an opportunity to present a true legal document.
Oh, so instead you would, so if you, now that you're on the hot seat, oh yeah, I guess now if I did it again, I probably wouldn't even give her any contempt. I would give her the opportunity to cure the defect. So you'd be wanting to go from 100 to 0. Oh, Tracy Hunter. It's a good question. I forgot. What was Hunter's issue? Oh, it wasn't it like wasn't it her thing like it was some nepotism, or trying to use her position for a relative or a friend. I can't remember exactly.
I'm presented with what I was on the bench. And so now, like I said, at that time, I didn't have resources where I could ask questions, or I didn't know what was what. So I'm trying to figure this out. I knew she was misrepresenting things and lying, and you submit a document. I'm from prosecution. So I know that document in prosecution would be considered a forged document.
What
No, it wouldn't.
what document here was forged?
Well, see, you don't know it's forged.
It's a certified translation. It's not a How can you say it's a forgery?
You don't know if it's untrue until you learn that it's untrue. So that's what I'm saying. So what you all are asking me or stating that I should have done was given her the opportunity to present a real document. That's what this hearing was for.
I just asked which document is forged. That's all I asked, not why did you do what you did?
Well, that
or
was-
do it different. Which you've now several times referred to a document as forged. Which document are you telling us was forged?
Well, the word was fictitious,
No, your word was forged.
Right.
I just heard you say it.
but what
Which-
I'm.
You said forged.
Document that we're speaking of, I'm not saying it's forged. I've learned that there is a true document. I got that true document, and I got the true birth certificate. So I had to see what it was. This is not, I don't know where you all want me to go. I'm taking the information that was presented to me in court, the sworn testimony, the document that was presented that wasn't a true legal document, as the support to change this record. And that's what happened from that.
When you obtained the true and accurate birth certificate, did you compare it to the document that had been previously filed to see if there had been any alterations, deletions, or any fraudulent, anything that was changed that would make you think it was fraudulent?
I didn't regard that. I didn't acknowledge this document
Is
because,
that a no?
yes, I did not. I used the certified translation.
But you know, from being a prosecutor and a lawyer, that there's a crime of forgery,
Yes.
and then there's a crime of altering public documents.
Right.
Two separate distinct things,
Mhm.
right? Forgery is not necessarily fraudulent or vice versa. Which one
Right.
did you say this one was?
Well, I was saying I didn't say it just wasn't a true document. It was not, she submitted a non-legal doc.
Where is the forgery? Is what-
No, I'm not alleging this was forgery. I'm saying at the time, I didn't know what it was. I just knew it was a non-legal document.
Right, so that's my question. You didn't know what it was. So how do we go from not knowing what it was to 20 days in jail?
It was
Yeah.
because it was topped with the information that was presented to the court in the court at that time. And this document that was presented, that's where I felt there was a direct contempt. And I felt like she was manipulating the court with the data, the testimony, and the document. And that's why the decision was made at that time. In hindsight, it should have been allowed for her to present her true document or a true data.
And I'm promise Ms. Veal, we're gonna give it back to you in just a second. But at some point during this hearing, it became apparent to you that you are now considering contempt. Did you stop at that moment and say, all right, I need to figure out how to do a proper contempt hearing. I'm considering potential jail time for this individual. Do I need to let her get a lawyer? Did any of those thoughts cross your mind, or did you stop, pause, and go talk to someone, go look it up, or do anything that might, give you some guidance on what you should do next?
At that time, I did. I believe she was in direct contempt for presenting the information that she presented to the court, and that's why it was done. So no, I didn't make calls or do anything. So yes.
Guess what?
Back to you, Ms. Veal.
Do you remember where you were?
I'm trying to mark off my questions as they're asked by the hearing panel. So Judge Peterson, you just said that I want to be clear that you didn't do anything, you didn't do any research or pause before you jailed this woman.
I did
Hold on,
research.
I'm sorry, 1 second. Sir, you're gonna need to silence that device, okay? Well. Oh, okay. All right. No. I didn't realize it was connected to that. You keep doing what you're doing. I apologize.
I'm sorry.
What to Mr. Lopez's point, did you ever pause and say, you know what, I'm about to jail this person, considering doing it for the maximum time permitted under the law? I need to do some research before I'm comfortable doing this.
I did, like I said, I had a contempt matter previously and I had done some research. So I knew what the allowances were, but I didn't, like I said, before the court.
You can, I mean, you can, depending on where you are, you can hold, a judge can hold somebody in direct contempt and send them to jail. Not necessarily with the presence of an attorney. It could be different from in other jurisdictions. Like again, the issue is that when you're doing direct contempt, the reason why the judge has this latitude is because it's on the record. Two, it's literally in front of the judge. So in both instances, there's a record to be made as to what the conduct was. So then if there's a challenge, it could be scrutinized. Here, there was no record. The parties had to bring in anybody that they wanted to record.
Court hearing, I wouldn't have known this was a contempt matter.
Sorry, Ms. Veal, I gotta interrupt again.
What
I
the
feel
fuck?
like you've just changed your answer. So now you're saying that you had previously done some research and you knew what you were supposed to do in a contempt?
I previously did research on contempt overall when I had the first contempt matter. When someone has done something in violation of a court order, then you have to have a hearing and things like that. But that's contempt where they're violation of an order. So I knew about that.
That's when it's indirect contempt. Big booty starfish. When there's an indirect contempt, that's what he said a hearing.
And as well as direct contempt if they're in the presence of the court. So that's information that I had researched and had learned about. If I had any clarifying questions, I had reached out. I didn't get full clarity because I reached out to the listserv. No one knew in the probate listserv. I'm sorry. It's a email list of all the probate judges.
Sidebar where all the
Yes.
Superior Court
Yeah.
judges chat amongst themselves.
Yes,
They don't think any of us know they do that.
right.
Got it.
So yes, I reached out to the listserv. I'll use the resources that were made available to me previously.
So at what point did you reach out to the listserv?
It was around the other action, the prior contempt matter. This was another case unrelated to this.
And nobody knew the answer to your inquiry related to your other contempt case on the listserv.
No, most people, the things that I heard from probate judges, they say there's more contempt power because the statute, it states a little more than the contempt in the Superior Court Code. So they say we have expanded power, but that's all they know. They don't know how to utilize it, what to do, nothing. They just say we just stay away from it. The ones that I talked to after the fact.
No probate judge on the listserv knew how to.
They didn't respond. The ones that responded said, I don't really know how to help you.
Well, you did some research on LexisNexis, correct?
Westlaw or Lexus, yes.
Okay. Did you look into the difference between direct and indirect contempt?
Yes,
Okay. And did you read about due process related to contempt proceedings?
yes, in relation to the due process that's required for the indirect.
And what is how do you understand due process for somebody in that position? What do they allow?
Well, now, I've done further research.
Oh my God. So this is the other major screw up here. Is because in her order, she gives the impression that she held her in contempt. She was going to find her in contempt during the filing. The problem is the filing was outside of her presence. Is what is it in a courtroom? So it would technically be indirect. If she's going to hold her in contempt, it would be indirect. When it's indirect, there are some due process obligations you're supposed to afford the petitioner before the hearing. She didn't do that. She basically ambushed her and was fully intent. In my opinion, she was fully intent on sending her to jail from the get-go. And yeah.
But in regards to a contempt, say if I have an order, if I issue an order and someone is not in compliance with the orders, say a conservator is not turning over money or something like that, I will issue a contempt notice, a hearing notice for contempt. I will also actually have them personally served.
How many of those have you done?
We do them often now because there's a lot of cases that are conservatorships.
I thought I asked you how many contempt and you said.
No, I've had hearings. I haven't held anyone in contempt. Yes, they have the hearing because they are evading court and taking people's, may be exposing people and their money. So we do conservatorship. So they're over people's money.
But with regard to this woman, due process, does it just mean notice and hearing?
Well, in this,
What other due process would she do?
well, in this one, I viewed it as a direct contempt. So I didn't know that I would have to give her order of a notice and a hearing. So
I don't know.
yeah. So in my understanding of the law, when it's a direct contempt, it's in the presence of the court, and that's
So
what-
I'm gonna pause you because this is not meant to be a legal quiz. And
Yeah.
I know Mr. Hyde is free to ask those questions, but I want to reassure you and really echo something Mr. Tate said early on, that none of this is about how savvy you are about the finer points of this or that, but we are just trying to understand the steps you took or didn't take, and what steps you thought ought to be taken now that you've had a chance to look back at it. But please don't come away from this wondering, well, gosh, I didn't know I was going to have to be the horn book on contempt law. None of us, other than maybe former Judge Lopez, is on that. So
Okay.
Don't worry about
Yeah, I didn't know
defining
that.
direct
Which-
versus.
Well, no, I mean, now, like I said, because we've had we do guardianships and we do a lot of estate work. We do see a lot of people mishandling estate. So I've had to have a lot of contempt hearings, and I do issue contempt hearing notices, and I have them personally served so they can't say they didn't get notice. And we let them know I draft the orders, because you saw how this one was drafted poorly. But I draft the order or the notices stating, hey, this is a contempt hearing. If you're held in contempt, you might be subject to incarceration or a fine. You have a right to have an attorney. You probably want to consult with one. This is not taken down. You need to get it taken down if you see fit. But you should be here in person on this day. You shall be here in person on this day and this time. So that's what I do now after further research and clarification of all the contempt matters.
Judge, you said that in hindsight, what you would have done differently is allowed PJ the opportunity to present the additional document that you wanted to see, correct?
Yes, I would have asked for, I just would have told her to bring a legal document to court.
Okay, without jailing her.
Right, right.
And in fact, you've had multiple opportunities to explain this situation and to offer what you might have done differently, correct?
No, how?
So this contempt situation was part of the basis for the first motion to suspend you, which was filed by the JQC, correct?
I'm sure it's been a lot, so.
Do you remember submitting an affidavit in conjunction with your attorney's response to the investigative panel's motion for interim suspension?
I don't remember,
Uh-oh.
but I'm sure it was probably done since it was a motion.
Uh-oh.
Would it help you refresh your recollection?
Yes,
Documents that were submitted with that motion for interim suspension?
yes.
Does this have a number, or it may, or right now it's merely refreshing recollection? Okay, Mr. Tate?
Yes, it may. it's what we submit as an affidavit to the interim suspension. I'm fine with all of this going in. In fact, I think I discussed, I might put at least tender both of those going in.
Right.
So have no problem with this being read.
Okay.
Have no problem with questions being asked about this, but there's something that I do want to make sure that I point out here, because the question that Ms. Veal asked was, you've had all these opportunities to say you would do something different. And, you know, what she puts in here is what happened. There wasn't any retrospective about this.
Well, okay, rather than narrate what's in there, you'll be able to follow. I have skimmed that before. I don't recall the specifics. Ms. Veal thinks there's something in there and is drawing your client's attention to it. She may acknowledge that she signed an affidavit. She may not. We'll see.
I think all of that's true. What I'm saying is it is not impeachment because she wasn't asked the question, what would you do differently here? For it to be impeachment, it has to be, what would you do differently here? Oh, then I said, I wouldn't do anything differently. Now today I'm saying, oh, I'd have another hearing.
That would be one form. So let's see where this
Did,
goes.
did the investigative panel ask?
I don't know. I was not at all investigative panel meetings about that. I was retained shortly before the first motion for interim suspension
Wasn't aware.
was there. We haven't had any contempts. Nobody's been jailed since then. So
Can I add to supplement that response to your question? She did come into the investigative panel meeting on October 15th of 2021 with Mr. Tate, and she did talk about the contempt issue.
Okay, I bet we're going to go there. But you were asking Judge Peterson about the affidavit she presumably signed and hopefully read in connection with the first motion to suspend.
What's the question?
So have you reviewed the document that I provided to you?
I reviewed the portion that you, yes, that showed me, yes.
Okay, and what is the document that you reviewed there?
An affidavit, my affidavit. It says affidavit of Christina Peterson for the Supreme Court case.
And
Oh, her
with
affidavit.
that affidavit, you offered your explanation for what went on with this contempt matter.
I did.
Okay, did you offer any reflection regarding whether you would do things differently?
That wasn't the request in this matter. It wasn't to talk about what you would do differently. It was to talk about what you were alleging I did.
Within what term did you use to refer to the document that we've discussed over and over again?
It was in that form,
Yeah.
illegal, not legal. It's,
Another illegal document?
yes.
in this affidavit?
I said illegal. That means not legal.
Yeah, she say, okay, I'm looking at her affidavit here. She says it was an illegal document representing it as a legal birth certificate. I don't know if a translated birth certificate would be an illegal document.
You said another illegal document.
Yes, illegal means not legal.
When you came before, actually, strike that. Have you ever before today said that you would have done anything about this contempt proceeding differently?
I'm not sure. I don't know if I've ever been asked.
Oh. I think in most instances, everybody would say that what PJ did may have been improper or
I believe
inaccurate.
Now to move on to our next complaint, it is 10:35.
But yeah, all right, we're done. And I was about to say, I hope we're done because I was done with this. Again, spoiler alert: she was found not guilty, but responsible, or found to have violated the Georgia rules of professional conduct, or whatever the hell they are, including her actions with this incident of the contempt. They held that the way not only was her trying to claim that there was a forgery was not accurate, but her trying to say that this was a direct contempt and not indirect contempt was improper. Veteran, I don't know if she's been disbarred. I know she's off the bench. She absolutely is off the bench right now. It would not surprise me if she were to find herself in front of the attorney disciplinary committee as a result of this. But I want to thank you guys. Honestly, I don't think she can, Tough. But I don't know what George's rules are, so I can't tell you that for certain. She was officially where was it? What was this filed? The findings. What were the findings? The report finding her to have done these things was filed March 31st of this year. And I think she was bumped off the bench last month. But I want to thank you guys. Much appreciated. Let's go ahead. I guess we can, is Biggin live? We can go ahead and raid Biggin then. It is hot in this PC room. I need to get out of here. Let's go ahead and raid Mr. Biggins. And I'll see you guys next time. Probably not going to stream tomorrow. But I will be, I'll absolutely be back on Friday, okay? Have a good night. Take care. Adios. See ya.